This conference will now be recorded.
Exactly.
All right, we'll call to order the Town of Ocean Ridge Special Magistrate Code Enforcement hearing. Today is Tuesday, April 5th, 2022. It's 10 a.m. First item on this morning's agenda is adoption of the previous meeting minutes from February 15th, 2022. I've reviewed those and I'll adopt those as drafted. Second order of business is to swear in anybody who's going to be speaking on any item here today this morning. If you could all stand and raise your right hands for me. Thank you. Do you all swear affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Thank you, sir. Looks like we have one item on the agenda this morning, which is not the typical process. So it's a fine reduction request hearing. In fine reduction cases, the respondent has the burden of going first and presenting their case first, and I'll hear from the town. With that, I'll turn it over to the town to call the first case and the respondent.
Good morning, Your Honor. Christy Gatt on behalf of the Town of Ocean Ridge. This is a fine reduction request hearing, case number 2021-008. Property owners are Albert and Patricia Thrower as trustees. The property address is 8 Inlet Cay Drive in the Town of Ocean Ridge, Florida. Just by way of background, as you may recall, this was brought to you in August of 2021 at the code enforcement hearing for a violation of work without permits for a floating dock. At that time, you entered an order finding them in violation and giving them until October 4th of 2021 to bring the property into compliance or face a fine of $100 per day. On October 5th, we came back for the fine assessment as the property was not in compliance. The floating dock was still there. And we requested an extension, which you granted to December 6th of 2021 because the property owner had applied for a variance and the application was complete at that time and they were scheduled for the November 17th Board of Adjustment hearing. So you granted the continuance of the compliance date to December 6th of 2021. The property owner went to the Board of Adjustment hearing on November 17th of 2021, and they received the variance for the side setback for the floating dock. They then submitted a permit to the town for the floating dock. Comments were provided back shortly thereafter by the town, and it was just moving through that process. In February of 2022, we brought it back for the fine assessment hearing, and you imposed the fine with fines running from December 7th through February. On February 4th, they actually removed the floating dock. So they did come into compliance on February 4th. They continued to respond to the town's comments on the building permit, and most recently submitted March 28th a request based on a DEP exemption for a floating vessel platform. The town clerk and the building official are present. The town clerk can testify to the total accrued fine amount, which I believe is $5,900. And the building official can testify to what the property owner did to try to bring this into compliance. Thank you.
Okay, thank you. Ma'am, are you here for the respondent?
Yes.
Can you approach the podium and state your name for the record?
Dr. Patricia Thrower, 8 Inlet Cay Drive, Ocean Ridge.
Thank you. So you've heard the background from the town. Go ahead and explain to me why you're here requesting reduction of the fine.
First of all, I'd like to say good morning and thank you for your time and your kindness in hearing me for this plea. I feel this has been honestly sort of a case of a little bit of coming after us, if I can say that, but let me start at the beginning. We received the initial Town of Ocean Ridge code violation description, which I have here.
Mm-hmm.
This was dated April 15th, 2021. I think we received it on the 16th. And it said that we had to remove, the word is in here, the action, required corrective action is remove the floating dock by May 27th. Of course, we were very upset by this. I know ignorance is not an excuse. We did not know we needed a permit for this. We weren't aware of the setbacks. When I asked the marine installer who did the work for us, who seemed like a reputable man from Deerfield Beach, he said, no, it's a floating vessel platform. You don't need a permit. I had no reason to doubt the man. I just went by what he said. We were very annoyed, of course, but I called him immediately. He came within 2 days. He looked at it and he said, we can't remove this. Remember, this is in the midst of COVID, number one.
Mm-hmm.
Number two, he said, because it had been there for 6 months, it had acquired barnacles at the bottom. And the bottom of this vessel platform was filled with water. So when it went in, it was perhaps 100 pounds. Now it's 800 pounds. He said he couldn't risk his men going in the water, getting scraped up by the barnacles, and removing this during the COVID season. He was down a worker at the time.
Mm-hmm.
Okay, so now I said, well, what are we going to do? We came back to the town. Everyone was very nice, particularly the town clerk, Carla Armstrong, was helpful to us. And she said, you can apply for a variance. If it has to stay there, you can apply for a variance.
Right.
Remember, we're going under the assumption we had to remove being the key word. So I said, what do we do? Carla was very helpful. She said, she gave us a list of things. We put together 13 packets for the Board of Adjustment, which cost us a lot of time and money and effort, which was fine. We did it. There was not a board hearing, is my understanding, over the summer. We are also not here during the summer, which is part of the problem as well.
Mm-hmm.
So the engineer originally, when we put this floating vessel platform in, I asked for it to be closer to the Intracoastal. He said it could not be placed there because it was too dangerous. In other words, from the wakes of the boats, the wave action, and plus, if it ever became loose, it would be a hazard to navigation.
Mm-hmm.
That's why he put it where it was originally put. So that being said, we couldn't get a variance hearing in a timely fashion because of, again, COVID. People were leaving for the summer. It was the end of May. We stayed through June, but we couldn't get a variance done. So we got pushed to October. We flew down here in October for the meeting. The meeting, we got bumped till November. That's fine, not a big deal. So in November, we came for the variance. We got the variance. Right then and there, they said, now that you have the variance, you need to apply for the permit.
Mm-hmm.
We said, okay. We went immediately. All the requirements for the permit. I was here no less than 3 times in 36 hours with paperwork and getting things signed. I went down to Delray to the courthouse, got things stamped, brought them back. I thought the application was complete.
Mm-hmm.
Again, I'm not an attorney. I don't pretend to know all the ins and outs of the legal system. At that point, we had paid $1,181.88, which included some fines for the application fee for the permit. We paid $1,250 to have the variance heard. We had a hearing fee of $188. We had a government revenue fee of $124. We had a $14 fee to Delray for Palm Beach to get the paper stamped. We then had to hire, I don't want to get ahead of myself. So my husband, I think, came before you and you granted very kindly and nicely our extension
Mm-hmm.
for this till, I forget the date, it was December 6th. We got the variance on November 20, somewhere around the 20th of November.
17th.
The
Yeah.
17th, okay.
Yeah.
The 17th of November. I think we all know what was going on. We had Thanksgiving. We had COVID. We tried to get all the things for the permit together. We could not get a hold of the DEP by phone or email. We could not get a hold of the Army Corps of Engineers. The number they gave us was defunct. I came back to town hall again and I said, I'm trying my best to reach these people, but I can't reach them. We did the best we could. We put together the packet. We came back to town. We gave it to them. Then on December, which I have here, December 6th, which was exactly, I think, the day that we were supposed to, quote unquote, remove the floating vessel platform, we got another plan review comment sheet from Mr. Guy. This is the day everything was supposed to be in. We thought we had everything in. On this day, we now get another with no less than 6 more requirements.
Okay.
We then set about getting these 6 requirements done on December 6th. With all of this going on, we completely forgot that that was again the date that this had to be finalized or done or moved or removed. So we went about getting all this stuff together. We had to hire a coastal engineer. That was another $1,500
Mm-hmm.
to get all these requirements done. Then because there was some issue with the Army Corps, they need to wait and do a seagrass study, which can't be done until the summer, which is now June or July of this year.
Mm-hmm.
So we can't even get that letter from them, which they told us in March.
Okay.
So that is letter C on our new list of things to do. Because my husband came to the meeting where we learned about the assessment of the fine of $5,900, we tried to set a meeting up with Mr. Guy again with the coastal engineer here, and this was on March, I think it was the 27th or 28th of March, I forget the date. Mr. Guy never came up for the meeting. My husband showed up, the coastal engineer that we paid, and Mr. Guy never showed.
Okay. This is in March.
This is the end of March,
Okay.
correct. Then we get another paper, plan review comment sheet, which I have here, dated March 9th. This is another town ordinance that they're now saying we exceed. And a copy of definitions and
Code, yeah,
more
code sections.
paperwork
Okay.
and more. Anyway, this was sent by someone who just signed it, Manny, who we did not know at the time. And the coastal engineer and the attorney said that indeed, apparently, again, I'm not an attorney, so I apologize, Florida statutes and what the Florida state statutes say supersede the town code, because you can't be more restrictive with the town code than what the Florida statute says. And that's all in this paperwork I have here.
Okay.
This fellow Manny, who my husband, I did not meet with him, but my husband did, and he said he was very nice. And he agreed. He said, okay, I see what you're saying. I understand. He understood the coastal engineer. Again, they're speaking the jargon. I don't know. He said he would bring this to Mr. Guy. He would discuss it with Mr. Guy, and Mr. Guy would get back to us.
Okay.
We still have not heard from Mr. Guy.
Okay. Can I
So-
see that paperwork that you have there?
Yes, this one?
Yeah, and can you give it to the town attorney first and ask her if she has
Is
any
that
objection?
the email with the Florida
not sure.
statute? Yeah,
I'm
I've
not sure.
I've seen, yeah.
You're
Yeah,
okay
we're
with
good.
that?
So-
We're good, yeah.
Okay.
Yeah, we're fine.
And who is Manny, just so I'm clear?
He's the zoning official.
He's a town zoning
Okay.
official. Okay.
Again, I did not meet, I'm sorry, I don't
No
know.
problem, no problem.
Okay. So ultimately, so it sounds like you still don't have a permit. You just took it out to stop the fine. Is that how the story
So-
is going to end, I
So
think?
then, throughout all of this, again, the wording that we received in all of the correspondence and emails and on the phone said you have to remove it, remove. No one ever said, throwers, if you just move the dock to the other side or 5 feet away or whatever, while we're going through the process, we would have done that immediately. I didn't understand that. Please
Okay.
trust me, I followed the rules. I went to 12 years of Catholic school. I'm a doctor. I have all my licenses. I follow the rules. If someone had said, just move it to here and then we'll sort all this out till we get the permit, I would have done that in a heartbeat. We wouldn't be standing here today. Every single time it was remove, remove, remove. and I couldn't get the marine installer to remove it. So I felt like I was kind of between a rock and a hard place,
Right.
honestly. And then I forget who, someone came over and said, well, if you just move it, Patty. I said, oh, okay, where do I move it to? Well, if you just tie it up with some ropes over here. Now I'll tell you, I welcome you to come. I live 1 block away. It's floating out in the middle
Right.
with the rope hanging onto it, which is fine because I'm there now. I'm leaving on May 18th. I don't feel comfortable leaving it like that for the whole of hurricane season. I know it'll come loose. I know it'll be blown away, destroyed, ruined, and perhaps a navigational hazard or cause some damage. We have kids going up and down on kayaks and paddle boards all day long there.
Right.
I don't think it's safe. People have already banged into it. Boats have banged into it.
Hmm.
I had a fisherman there yesterday who banged into it. I mean, because it's moving. It's
So-
unstable.
Right. So what are you requesting the fine be reduced to?
Ultimately 0, I would like. I mean, I just don't feel like we even had a shot at getting this resolved in the 2-week time period between the time we got the variance with Thanksgiving, COVID, people not around till December 6th. We just didn't even have a shot at it and as much as I tried to get all the paperwork in, we were handed things on December 6th with another laundry list of things to do.
Right.
It just seems like every time we took 2 steps forward, we took 1 step back.
Right. So let me ask the town, what is the actual date of compliance on this? Do you?
Yeah,
2/4.
February 4th,
Okay.
2022.
Yep, if you scroll down the thing that I gave.
Is there a copy? Okay.
When the building official.
Okay.
Yeah.
So I guess the question I have is, unfortunately, you didn't come to the violation hearing. Had you come to the violation hearing, that's the time when the discussion about how to remedy the violation occurs. So that's where your husband came to the second hearing, actually at the third hearing, the fine assessment hearing. But had you come to the violation hearing, that discussion could have happened, either get the variance or meet the town code or remove the dock. Were you not in town?
We leave here typically about the 2nd or 3rd week in May. This past year, we stayed through June, till June 18th we were here to
Yeah.
get this resolved, and we couldn't get it resolved.
Okay.
And that's when everything got bumped and bumped and bumped for the variance hearings, which I understand. I understand these people leave, people go on vacation. I get it. But I'm asking for some consideration as well, because there really was nothing we could do. We stayed an extra month.
Right.
We have children and grandchildren. I have a sick mother who's dying in New Jersey. We go back to New Jersey for the summer.
Right. I understand. Yeah, I understand. There's life.
And then
Life
we
going on.
flew back in October, in between a whole bunch, not that this matters, stuff going in New Jersey, it doesn't matter, it's irrelevant. We came back, we flew back, and then the meeting was what happened to the meeting, Carla? That we were supposed to go to October 20.
So, and just, I looked just briefly the history, if I could just say so. They submitted late May.
Let me swear you in before you continue. Do you swear affirm to tell the truth, the whole truth, and nothing but the truth?
I did.
Thank you, ma'am.
I looked at, and just briefly the history, because I'm trying to remember it all on the computer. So you guys submitted late May, your variance. It did receive comments. By the time you guys received comments, you were already gone for the summer.
Right.
And I know your husband was trying to do the package from far away.
Yeah.
So you guys had a complete application was received around August time, where you guys already still gone for the summer.
Yes, we were.
And per the code, because I talked to the attorney at that time, we could push it for 60 days after we have certified it, and that's how you were able to get into the November, or maybe it was September we certified it. And we did that as a courtesy, because I know you guys were away for the summer, and I was trying to coordinate with you guys to make sure that you guys were here in the Board of Adjustment for a meeting. So it didn't necessarily have to be with them not being able to hear it before, because they could have heard us since you guys were certified, but you guys were not here. So I was trying to coordinate it with you all being here too as well, because you guys needed to be here for the meeting.
But there was no Board of Adjustment meetings in August.
We scheduled them.
Oh,
We scheduled them, and your husband has said that you guys are not here for summer, and if it could be pushed. So we schedule them on a case-by-case basis,
Oh,
So that's why,
because I know people in the Board of Adjustment weren't here either.
yeah, but there's alternates, and usually if I at least have a
Oh,
quorum
oh, oh.
of 3 people, so that's what happened during that time. You guys were not here, so that's why I pushed it
Got it,
to
got
a
it,
time
got
when you
it,
guys could be present for the meeting.
got it, okay, okay.
So what's the town's position on this mitigation request?
I think we should hear from the building official. I think, I don't have any objection to what Dr. Thrower is saying. I think the only thing, and I'll let the building official speak to it, was that from the beginning, his direction was to have it removed, and the throwers apparently took that as it's got to be picked up and taken out of the water, but pursuant to our code, it just couldn't be in violation of the side setback. So to move it and put it in a place where it wasn't in violation of the side setback, because that's what your variance for, is really what would have brought it into compliance. So that was the comment all along, that you're in the side setback. So that was the problem that we had. But I can let the building official explain more.
Go ahead, Mr. Guy.
So, thank you, Town Attorney. Good morning, Your Honor. So this whole case started as a complaint from the adjacent neighbors, 6 Inlet K Drive, as a nuisance to them. The dock, the floating structure in question, actually has a yoke on the side of it, and stacked on that yoke are some paddle boards. And the paddle boards were a nuisance to the neighbors, and that is how they complained. So when we actually pointed out the violation to 8 Inlet K, it was for the dock being within the setbacks, which was the violation, and a requirement that it be removed, as she testified. So I have a picture up right now of the property. The top portion where that boat is, that square is the floating dock. And as you see, it's right up against the property line. It's in line with that red line between 6 and 8 Inlet. As you also notice that there's a whole heap of frontage all the way around. The property to the bottom of the page has a floating dock structure that's on that side of the property. I'd estimate that's over 200 feet of linear frontage of thing. There are many options that I do believe that this property had to place that structure. Other people have done it, obviously, like the neighbor to the north. There is a dock there. They had all that space. So we were clear it needed to be removed. We didn't state that it needed to be removed and disposed of, destroyed, lifted up, put in the yard. That was never there. We also sent the code article that made an explanation of the difference between an attached structure and what's called mooring, which is actually what's happening right now, where it was moved to the front of the dock, just kind of behind where the boat is right now, and tied off. According to our codes, a permit is not required.
And I remember that there was discussion of that at one of the previous hearings. I
of the
remember that
structure.
discussion,
So
yeah.
I do believe that they were made aware of what the requirements were. It's unfortunate that, I mean, there was a misunderstanding, but I think we did our best to point that out. So the process of the permitting began obviously after the Board of Adjustment had granted them a variance within the setback. They were now given an additional 7 feet. So once the permit was received, the permit was deficient because it did not show actual engineering drawings. It didn't show actual scale. It just stated that the dock was at the correct size. According to what it looked like, it didn't seem like it was even within the thing. So comments were issued. And the comments that the round of comments has not changed since their initial thing. So it's not like we sent out a new thing. They were never addressed. They were not properly addressed. With regards to our zoning official, once we finally got a drawing that showed the dock later on in another location or another configuration, let's say, was a proposal that was sent to review by our zoning official, which is normal. So
Mhm.
now we had a survey showing, another configuration of the structure, no scale. And it went to Manny Palacios, who did that review. And the day that the meeting was set up, I was at work earlier. It was a late meeting, and I wasn't feeling well, and I did leave for the day. However, that meeting was attended by a contract representative. So they did meet someone, not with me personally, but they met with the person who gave the review, Manny Palacios.
Okay,
who is
so they
also-
met with somebody
Right,
from
so
the
just to
town
be
was at the
clear,
meeting.
That comment
Okay.
about the extension of the dock into beyond the 5 feet was actually made by Manny, and the person they met with about that was actually Manny. So those were comments that were given, and that is still being resolved. When the actual structure was removed, I don't think it took very long for the workers to actually move it, which is what we've been asking for now for almost a year. So again, that's our perspective, and from the building officials and the building department's point of view, code enforcement point of view, is that this structure could have been moved almost a year ago. It didn't have to take the pressure from the board, which ultimately what I do believe it was, when they noticed that the fines were accruing, is when there was finally an urgency to move the structure. So we are.
I would like to address several of the comments from Mr. Guy, Your Honor, if I may.
Go ahead, ma'am.
He pointed out that that is not a floating vessel platform on the north side of my neighbor's property. That is a raised platform with motorized vehicles on it. It's a platform that has 2 wave runners on it. We don't have motorized vehicles. We don't have a need for a raised platform. Our platform is in the water.
So that other structure you were saying is not in the water.
Correct.
Okay.
And from that, it would be hard for you to know that. That is a raised platform. So that is protected from the waves.
Mm-hmm.
It's not battered by waves and boat wakes constantly. Whereas if ours was placed out there, it would be. It would also be a hazard to get on and off the kayak and the one paddle board that's there for my grandchildren who are under the age of 6.
Okay.
So all of those features were mentioned at the Board of Adjustment hearing. And we did have 3 of the members of the Board of Adjustment, or maybe 4, I forget, come to evaluate the property and look at it and see it. And that's why we were granted the variance, because it just simply made sense to put it where it is now. And again, all the paperwork we received used the word remove, not move. If Mr. Guy had said, look, Dr. Thrower, can you just move this with some ropes to the other side until we sort this out? I would have done it. That would have been the simplest thing for him to come to me and say, please just move it until we sort it out. That would have been fine. To remove it was a huge issue. It's still a huge issue.
Right. Okay.
The fact that he's saying this could have been done immediately, again, may I point out, it's hurricane season. It's June 1st, and all this is going on now. And I'm leaving. Now I'm going to have something tied up there, not secured, right in the Intracoastal Waterway for all of hurricane season. And then what would have happened if some child got injured or somebody hit it with a boat and it was destroyed? Who's responsible for these things?
Right.
That was my concern, and that was the concern of people that came to look at it.
Right. Does the town have a recommendation on the mitigation request?
Well, Your Honor, I just want to point out that the fines only accrued from December 6th to February 4th. So that was the time frame that the extension was granted to. So they really didn't have to come into compliance until
December
6th.
6th, correct, right.
Your Honor, I guess looking at the factors that you look at and setting the fine and determining, I don't believe the Throws have any prior code enforcement history. So there's no prior history with the property. The severity of the violation, this violation was work without permits. The floating dock had been there for 6 months or so with the barnacles attaching to it. So the work had been done clearly without a permit. And that's a serious violation because obviously, it's the issue of not following the proper procedure to get the permit. They, as Dr. Throver said, they've done enough, actions to try to bring it into compliance. Sounds like perhaps they didn't understand the direction of how to bring it in compliance right away. Normally, the town doesn't take a position on these types of fine requests. But going through that, I think that splitting perhaps the fine that has accrued would seem fair. Obviously, they still have to go through the permitting process for looking at potentially if there's a DEP exemption that may apply to this and what that allows and doesn't allow for. But they still have to finish
Get
up
through
that
the process. Okay. So the difficulty, as she said, the difficulty is I think there were residents, I think it was your adjoining neighbors to the, whichever direction that is, east or west, but I think they appeared at least one, I think two, if my memory is correct. And I think I even on one of the hearings prior to the hearing received correspondence from them, written correspondence. So I do remember that there was quite a bit of concern from your neighbors about the location of it and the proximity of it to their property line and to the impacts on their whatever boat or dock structure they have there. I think they spoke about at the hearing. As the town attorney said, and as I indicated to you previously, I just wish you had come to the first hearing. Had you have come to the first violation hearing or called into the hearing, back then I think they were doing phone call-ins to these code enforcement hearings. That's the time you get the greatest latitude, and that's really the critical time for you to understand how you get into compliance with what Mr. Guy has put on his notice as a violation. It's not the town's burden to call you and explain to you exactly what removed the dock or any other language that he's put in the notice. That's when you come to the hearing, that dialogue happens at that time. So it's unfortunate that you didn't appear at that first hearing, because I think, as has been indicated here, this is the town, in my view, the town was very willing to work with you. They granted extensions. They supported an extension request to allow you to keep the dock where it was and go through the Board of Adjustment variance process and not start fining you earlier before you were even able to go to the Board of Adjustment. So it seems to me that the town did try to work with you to let you get ultimately what you were seeking, which is to keep it where it was. So to completely remove the fine, I don't think that doesn't seem reasonable to me, especially given the fact that this was a complaint-driven violation and there are other residents in town who are affected by your actions.
Can I
Go ahead.
address that? I'm not trying to interrupt you. I
No, go ahead.
apologize. I'm sure you have no way of knowing this. Our neighbors, we put that dock in November of 2020. We had cocktails with them at their home. They invited us to cocktails. It was very cordial. It was very nice. They never mentioned the floating dock. They never said a word. It wasn't until the neighbor east of them, number 6, put in a floating dock with a motorized, again, a wave runner. That was the one that was very close to their property line. That was the one they complained about. And that was the one they called Mr. Guy on. It wasn't us. And then when Mr. Guy was there investigating the complaint at number 6, he apparently looked and saw ours, is what I was told, and he cited us, which is fine. When we got the citation, we did speak with our neighbor and we said, why didn't you tell us that you were disturbed by this? You never said a word. We had cocktails at your home.
Right.
Why didn't you say something to us? And he said, oh, it doesn't bother us. He goes, but you have to obey the rules. That was his answer. And that's fine. Okay. But he never did come to us. We had a cordial relationship with them. We were in their home.
Right.
I don't understand why he wouldn't have said, gee, Patty, that kind of bothers me. I don't like the way that looks, or whatever.
That's very common for people to call code enforcement
I don't
instead of dealing directly with their
I was
neighbors.
kind of shocked when it happened. And then when I asked him, he honestly looked at me and said, it doesn't bother me. It's just that you have to obey the rules. Now, these are elderly people. They don't have a boat. They don't have a dock. They don't have any platforms or anything. They hardly leave their home, honestly. But for whatever reason, now it bothers them all of a sudden.
Right.
And that kind of came out of the blue.
Heard that.
Go ahead, sir.
But it actually was the opposite. I was called specifically for
This
that
property.
structure, and specifically for the yoke that was there. The yoke had an elevated thing, and it had a paddle board, and the paddle board was dancing. And it seemed to me it was, I mean, this is the best way I can describe it. It was like a floating banana in the air. That's what it looked like, and it was annoying. I mean, I was there talking to them, and you had to keep looking over because it was dancing the whole time. And while I was there, I noticed the neighbor. At the same time, we notified both neighbors, to the east and the west. And the neighbors to the east removed theirs within days. It was pretty much a like for like, exactly the two structures. And the neighbor complied immediately, and their case was dismissed. That never was brought.
Okay. And so you have paid the administrative costs, is that correct? For all of these, I think I'm looking at receipts for,
Yes, ma'am.
I have record of 3. So any reduction would be separate from the administrative costs that have already been paid. Is that correct, town attorney?
Correct.
Okay. Anything further from you, ma'am?
No, Your Honor, I think you've been very fair, and I'm just asking for your consideration for this because it's already been a very costly process, not only mentally and emotionally, but monetarily.
Yes, I totally understand that. Anything further from the town?
No, Your Honor.
Okay. And I'll give you these back. Do you want these? They're not exactly a record for this morning's hearing, but I'll just give them back to you.
It's fine, thank you.
Thank you. Not a formal case file for this morning's hearing. But I have heard what you've said. Again, if you ever get another notice of violation, I would strongly encourage that you make sure that you appear or have someone else appear on your behalf at all code enforcement hearings at the initial violation stage, because that's the time to be here in this room and ask questions of the building official or the zoning official or whoever else, so that you understand what exactly the violation is and how exactly you can cure that violation, so you don't get into the scenario that you're in where you have a fine that ran for a brief period, but still a period that amassed a bit of a fine. I have heard what you said. I have considered, your travel schedule and the fact that it seems like there was diligent pursuit of the permit. I just again wish that your husband or yourself had appeared at that first hearing, so the building official could have made clear that the simple solution would have been that next day, move it so that it's not in the setback and not a violation of the town code. Then you can get through the permitting process to put it back where you wanted to have it. The town, although they don't typically recommend reduction, seems like they're sympathetic to a reduction in this case. So in case 2021-008 for 8 Inlet K Drive, I'm going to grant a reduction. I'm going to reduce the fine amount to $3,000 payable within 30 days. Yes, ma'am. And just understand, if you don't pay that reduced amount, it will revert back to the original fine amount of $5,900. I do understand, but I have to take into consideration the fact that there were other town residents affected. As you said at the beginning of this, ignorance is not an excuse. You knew you had a violation. You have the paperwork there. At all the previous hearings, I would have found good notice for those hearings. Your husband appeared. You knew that a fine was running. So again, I hope that alleviates some of your financial burden, because you have had to go through other processes. But it is important to uphold the town code. And it is a severe violation if it's encroaching into a setback that close to a neighbor's property. So I'll grant that reduction. You'll get an order in the mail that reflects that. And I hope, again, if you get any future violations, please come to that violation hearing. Thank you, ma'am.
Thank you.
Anything further from the town?
No, Your Honor. That concludes our agenda.
So we will stand adjourned at 10:39.